Hi, everybody. Welcome back to the Wright on Crime podcast. My name is Rachel Wright, and I'm here with Alex Rienzie.
Hey.
Welcome to the podcast.
Thanks for having me.
So you know Michelino Sunseri, yes?
I'm familiar.
Yeah.
Spent a lot of time with the guy over the past year.
Well, we are bringing you and Michelino to the Wright on Crime podcast because of your all's very unique and kind of bizarre circumstances of dealing with the legal system, criminal justice system, through a unique set of facts for overcriminalization. So tell us how you know Michelino, how you got involved, and what this case was about.
Yeah, so originally know Michelino from a running club over in Teton County, Idaho. We used to go on runs up to Grand Teton up in the National Forest, and then we went on a couple ski tours together. And then I became closer to him through the Grand Teton FKT, or speed record process. Connor Bergsmith and I are making a documentary about his run. That's how this started. And then I got a little bit more involved in a different capacity as things took a turn from the world of mountain running into the world of the criminal justice system.
So how does that's not a natural segue.
No, it's not. So Michelino, as I think you already spoke to him about, was charged with a Class B misdemeanor for running on allegedly closed trail. And he faced the full brunt of the criminal justice system without the resources to fight back. It's really expensive to mount a defense and do all of the things you need to do to have a chance. Motion to dismiss to preserve issues for appeal, discovery request, motion to compel. Lawyers charge by the hour, and they charge a lot. Michelino couldn't afford to have a private criminal defense attorney to mount that fight. And so eventually I decided to jump in as a pro bono attorney. And this is my first case. But nobody else was lining up pro bono to back him up, so I stepped in.
That's great. So tell us, what were the charges?
Yep.
And how did this case not get dismissed? Because my understanding is it was essentially going on the wrong part of a trail during a timed run for the fastest record in the Grand Teton National Park. Going on the wrong trail, yes, we need to preserve natural beauty of these amazing places we have in the United States. But there was no public safety element that was being violated. There was no one being harmed, but he's still indicted and prosecuted, right?
Yep. This one didn't make much sense from the outset. So the regulation is 36 CFR 2.1b.
A true lawyer
citing
the CFR.
Which actually has some very sensible applications. It allows park superintendents to designate specific trails for travel that you can't deviate from in certain areas of the park. If that's not used, it's legal to go anywhere in the national park off trail. So a good and reasonable application of that would be the boardwalks up in Yellowstone National Park.
Sure.
You know, you have hot springs, obvious danger. Many people have died. And you can do long-term damage with very little impact.
Right.
And I think this court that we went before is based in Yellowstone National Park, so they're used to seeing those cases, and they applied that regulation to this. What Michelino did, though, is run on an old trail. There are many, many, many unmaintained trails in Grand Teton National Park and other national parks. They actually, I think by mileage, outnumber the maintained trails. And this one's been in use by climbing guides, rangers, mountain runners for decades. Almost all of the prior speed records have used that trail. But he used some language that, became unfortunate, which was cutting the switchbacks. And sometimes, but very rarely, these regulations are applied to keep people on switchbacks, which are zigzags going up the mountain, to make travel easier and to decrease erosion. If it might have made sense to apply that to Michelino's conduct if he was running from an upper trail to a lower trail and kicking rocks onto people, or running over sensitive foliage, or maybe up in the high alpine where there are moss and lichens and things that take time to regrow. But here he was running through the forest, basically at valley level, sagebrush, grass, pine trees, on a hard-packed single track trail. So this was just a bad application of that regulation that otherwise has good uses.
So how was it even applied in your case then if it was a bad application? Was that the charging document? Was that the judge?
The rules are very broad.
Okay.
Basically, I mean, there are two signs at either side of this trail. Both are ambiguous. Both were installed 40 years ago. And we had trial testimony that at the time that these were installed, rangers were still openly using the trail. And mountain guides occasionally took the Wright clients on this trail. And we had another ranger say, this trail is for locals only.
Yeah.
So I think rangers were trying to discourage people from taking the trail, but the current crop of rangers didn't have that history. They didn't appreciate it. The origin story of that trail and why those signs were installed in the first place, and some of the ambiguity that has led people to think it's okay in some quarters and not okay in others.
Yeah, so the prosecutor here probably thought this is a good example to use to show the force that this could have for other cases.
Yeah. And I mean, I'll spare some of the details with this particular prosecutor. But I actually hoped when I came on the case and I started making the arguments that she would see that the application of the regulation in this case doesn't make much sense. And then come to the table on a reasonable type of diversion. You know, we offered community service, I think 5 separate times, up to 100 hours. We offered to partner with the Park Service and, shake hands and pick up shovels and close the trail the right way if that's really what they wanted.
Sure.
But like often happens with DOJ and line prosecutors, in this instance, she dug in her heels.
Yeah.
And decided to take this all the way to trial.
And a lot of prosecutors have not only the discretion, but the encouragement to do some. So what ended up happening with the case? Was Michelino convicted?
So we had a 2-day trial back in May, 20 federal employees in attendance, I think 6 rangers and, tactical gear, bulletproof vests and body cams and all that, which was a great use of taxpayer money. 2 days. And we had cross-examination of witnesses about unmaintained trails versus designated trails versus user-created trails. The silliest, we had 5 government witnesses or non-government witnesses say they didn't think the trail was illegal, including the first and star witness of the government. We had rangers say, I'm not aware of any other requirements attached to the regulation I'm trying to enforce, despite the fact that the regulation right in the main paragraph says you need to have notice, you need to have a written determination. So the trial was surreal. And then 2 months after trial, the judge ruled guilty, denied our acquittal motion, denied a motion about Brady evidence. Another fun fact here is the Park Service actually withdrew from the case before trial, but that wasn't disclosed to us. Even the Park Service didn't support this thing before it went to trial, and yet Department of Justice, under the current framework, had the discretion to keep moving forward anyway. And so he was found guilty, and he was about to be sentenced this past fall.
And then you say about to be sentenced. So was he never sentenced?
He was never sentenced. 2 things happened. First, U.S. Attorney Darren Smith stepped in and extended a pre-sentencing diversion deal, which is what we'd been arguing for all along.
Right.
60 hours of community service. The case gets put on ice for a year, and then it's dismissed upon completion and subject to typical probationary terms. And then we got a phone call and an email from an unexpected source.
Who was a source?
Deputy White House counsel.
That's amazing. That is a spam number that you don't want to avoid. An unknown number, I mean.
Yep. And then, the email said, attached is a pardon from the President of the United States.
Wow. So that's an absolute roller coaster of a case. And now you are using your incredibly well-earned knowledge of the system in this unique circumstance to kind of motivate you to say, this is government overreach. This is poor use of prosecutorial discretion of taxpayer resources. How are you funneling and channeling that knowledge and passion forward?
Yeah, well, I mean, I'm just following the good lead of you and Brett and Right on Crime, getting in there. And we've been chatting with a lot of staffers on the Hill and some members directly, including both sides of the aisle for House Judiciary and Senate Judiciary, to try and encourage them to move forward on the Mens Rea Act and Count the Crimes to Cut, which are already up and introduced. And then also your expungement bill, which I understand you're making some strides on.
Yeah. So first, let's touch on the Mens Rea Reform Act. So for those who are not really in the weeds on criminal intent, why is that bill in particular meaningful to you in this case?
So many of these regulatory crimes, including I think virtually all of the National Park Service regulations don't have a mens rea requirement. Mens rea means guilty mind, right? You need to know that you're doing something wrong. And for a lot of these regulatory crimes, why would you think you're doing something wrong if you're running on an old trail?
And regulatory being that it was that CFR you were talking about.
Yeah,
but it's
exactly.
also not like, it's not murder.
Not passed by Congress.
Yeah.
Nope.
Not passed by Congress.
Not an obvious, not something that's an obvious wrong. and not something that's passed by Congress directly. There are so many instances where Congress has delegated broad rulemaking authority to federal agencies and then attached criminal penalties to any violation of said regulations. A more sensible approach would have been maybe a small civil fine for minor regulatory violations and then criminal reserve for just knowing and willful conduct. But that's not what Congress did. And I think it's built up over 50, 60 years.
So how does the Mens Rea Reform Act help remedy that? And then this also leads into count the crimes. That sounds very much, hand in glove.
It does. So mens rea reform would require knowledge of the illegal conduct by the defendant. Knowing or willful would be read in to any regulatory crime where there's non-existing mens rea requirement. So in this case, that would have put the onus on the Park Service to provide clearer notice, especially where you have an ambiguity. Something as simple as trail closed under penalty of 36 CFR 2.1b, I think would have given them a good argument that Michelino knowingly and willfully, violated the law when he took that trail. But those aren't the signs that were installed. Right. And likewise, in the superintendent's compendium, they had a single bullet point that said switchback cutting is prohibited. But that's not particularly clear as it applies to an old trail, that's been used over the course of decades, including by prior speed record holders and rangers and mountain guides and a whole host of people up to this summer. It's still being used today.
Yeah. So mens rea feels like a very, maybe not simple, very straightforward policy. So how have your conversations been going?
Oh, they've been great.
Good.
I think there's genuine bipartisan interest in fixing the overcriminalization problem. And there are some details that I think they can, iron out with some compromise language.
That's excellent.
From my conversations with staffers on both sides.
Wonderful. And for Count the Crimes to Cut, that one deals with, sounds like what it sounds like. You count how many crimes are out there?
Yeah, I don't envy the person who has that job.
Yeah.
I guess it's AI. I don't know. It seems like a tall order. I mean, what's your estimate on the number of regulatory?
What I've heard is somewhere over 300,000.
Yeah.
But there's actually no way to know because it's not very straightforward. So even as you begin, it's a subpart, whatever, referring to something else, and it's a complete mess.
Yep. And I think the two of those in combination will do a lot. And then there's your third bill, which I believe you can talk about now.
Yeah. So I think that your all's case is very illustrative of the need for this because not only is this a crime that everyone just kind of goes, wait, what? But also your client, Michelino, received a pardon from President Trump. The way that the federal criminal justice system is totally different from states where expungement and record sealing opportunities are available for a lot of different crimes, but usually your nonviolent crimes or things where there has been a pardon extended and accepted. In the federal system, that is not the case. And so we are very excited to be working with the likes of the pardon czar in the White House to try and figure out how in the world can we make this a better system, more fair, actual proportional justice, and provide those kinds of petition-based opportunities for a lot of individuals who are going to have a scarlet letter for the rest of their lives. So we are excited to work on that, and we think it would impact Michelino's case, absolutely.
I think it's huge and it's a no-brainer. And I believe it provides for automatic expungement as currently drafted for any non-conviction dismissals. So right now, if your case gets dismissed in a motion to dismiss, you still have the complaint or whatever on your record.
If you're arrested, that shows up in a record search as well.
Even if it's a wrongful arrest.
Yeah.
If you were arrested and it was deemed to be an unconstitutional arrest, it would still be in your record. There's no way to expunge it. Yeah. It's a no-brainer, and it aligns with what states are already doing.
Yeah. Great. Well, I have another question about just kind of broader criminal justice issues. How would shrinking of the code, is that a positive or a negative policy goal?
Well, I mean, I guess it always, the devil's in the details and depends what part of the code you're talking about.
Right.
I think in this case, the parks are overwhelmed with visitation. They need a way to enforce regulations to keep things a little bit sane in there and prevent resource damage. What I think would be very appropriate, even if they were to keep the regulatory footprint as is to shift most of those regulatory violations to the civil system, so that people don't end up with criminal records that then impact registration statuses. We've had a lot of registered nurses reach out to us who have run into different issues with the Park Service who, for very silly things, I think one of which Michelino shared with you, then worry about their jobs going forward, or housing or travel. Michelino for a while was worried he wouldn't be able to visit his girlfriend's family in Canada because they have a bit of an issue with people crossing the border if they have a criminal record. So I think the civil system would be better suited for a lot of these things. And the devil's really in the details, though. It depends what area of the code you're looking at.
Oh, right, because you're not trying to cut things. They're actually keeping,
Yeah.
national security interest at the forefront, or cutting things
Yep.
that would protect us from being able to just like have jobs and go to work. It's more of like, I think there's a bill by Representative Andy Biggs that contemplates eliminating certain pointless crimes. Like
Yep.
if you're trying to ship Swiss cheese, but there's no holes in it, that's currently a federal crime. It just feels kind of silly to me. So do you have any ideas on what safeguards could be put in place to kind of prevent what we would say is, in particularly Michelino's case, kind of almost like hidden rules? What can make that more transparent and a better process?
Well, I mean, count the crimes to cut, and then whatever type of federal register and notice comes with that.
Sure.
And just, I think intrinsic in the Mens Rea Act is shifting the onus of notice back to the agencies that are trying to enforce these regulatory crimes. If you are going to hit someone with criminal charges, you better provide sufficient advance notice for things that aren't obviously illegal or wrongful before tracking this through the criminal justice system and involving prosecutors and judges and private defense attorneys that rack up bills. And, in the case of Michelino, drained through his savings account. He had a van that he had to sell this winter to, keep up with his legal bills.
Yeah.
So I think Mens Rea Act would go a long way toward shifting the notice burden back onto the government. Eliminating some landmines.
I think that makes a lot of sense. And you mentioned at the beginning the authority that Congress has to do these things, but has been outsourced largely to the agencies. So that's also a larger conversation on how to navigate your legislative branch with kind of this administrative fourth branch. But if those reforms you just mentioned, you said mens rea reform, and then we talked also about Count the Crimes to Cut Act. If either or both of those had been in place, do you think that Michelino's case would have been prevented? Or at least better
I think
outcome?
it certainly would have been overturned on appeal.
Okay.
For due to local circumstances, I wouldn't have been shocked if it also got to a guilty adjudication.
Sure.
I'm sure that it would have been overturned on appeal in that case. And I'm pretty convinced that we would have won the appeal on Michelino's case had it moved forward. Just due process notice alone.
Yeah. Well, I think that this has been a really illuminating conversation on how these circumstances and these kinds of cases can happen to anybody, and that overcriminalization really is a big deal. So thank you for being here. And
Thanks for having me.
Thank you for joining us on the Wright on Crime podcast. And to reach out to our team and learn more about these issues, please visit us on our website, rightoncrime.com.